Started. I'd like to call to order this regular meeting of the Lincoln Lancaster County Planning Commission of August 31st, 2016. A printed agenda is available outside the hearing room, and a copy of the full agenda, including staff reports, is available at the front of the chambers with the clerk. The Open Meetings Act is posted just inside the door at the back of the room. If you parked in the parking garage across the street to the north, the gate is open and no parking coupons are necessary. Out of courtesy for those attending this meeting, the commissioners and staff, cellular phone usage is not permitted in these chambers during any portion of this meeting, and we appreciate your cooperation. The Planning Commission action today is final on all of today's agenda items. Any aggrieved person may appeal final action of the Planning Commission to the City Council or County Board by filing a notice of appeal with the respective clerk within 14 days following the action of the Planning Commission. First item of business is the approval of the minutes of the regular meeting held August 17th, 2016. May I have a motion?
Move approval. Harris.
Second, Lust.
Thank you. Please call the vote. Jerry?
Core,
Yes.
Harris,
Yes.
Lust,
Yes.
Sunderman,
Yes.
Weber,
Abstain.
Shear,
Yes.
and Hove.
Yes.
Motion carried 6-0 with one abstention.
The next item of business is the consent agenda. Items on the consent agenda will be called at the same time and will not be scheduled for a separate public hearing unless there is a request from someone wishing to speak or at the request of a commission member. I'll ask Jerry to read all the consent agenda items into the record. Once those items are read, she will ask if there is anyone wishing to speak. If you wish to speak on an item on the consent agenda, we ask that you stand and state that item. That item will then be removed from the consent agenda and scheduled as a separate public hearing under Section 3 of today's agenda. All items remaining on the consent agenda will be voted upon in total with a motion for approval. Jerry, will you please call the items on the consent agenda?
Yes, item 1.1 is special permit number 1020I for authority to amend the site plan for Bryan Medical Center West as most recently amended by special permit 1020H for non-residential healthcare facility to reflect the demolition of the former Sophie Teeters nurses residence at 1650 Lake Street and to change the use of that area to a memorial garden / open space with parking for access to the memorial garden generally located at 2145 South 17th Street. Item 1.2 is special permit number 16038 to allow the reduction of the front yard setback to 17 feet for construction of a new detached garage on property generally located at 1220 North 51st Street. Item 1.3 is special permit number 16039 for a new special permit for a kennel with waiver of the rear yard setback for the outdoor area on property generally located at 2301 Highway 2. Item 1.4 is use permit number 78 to increase the total square footage to 17,300 square feet and add residential health care and elderly retirement housing as potential uses on property generally located at Kensington Drive and North 27th Street. And item 1.5 is use permit number 126E for the reduction of the rear yard setback from 15 feet to 10 feet and the side yard setback from 15 feet to 5 feet on Lot 2 on property generally located at Executive Woods Drive and Wilderness Woods Place. Again, this is final action on all items unless appealed to the city clerk's office within 14 days. Are there any ex parte communications to be disclosed on these applications?
I see none.
Is there anyone here wishing to speak on any of these consent agenda items? If so, please stand and state that item.
I'd entertain a motion.
Move approval. Lust.
Second.
Weber.
Go ahead.
Thank you. Jerry, please call the vote.
Core,
Yes.
Harris,
Yes.
Lust,
Yes.
Sunderman,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried 7-0.
I'll now ask Jerry to call any requests for deferral received prior to this meeting.
Okay, on agenda item 2.1, special permit 16009 for the construction of a carport on property generally located at 1801 Kings Highway. The applicant has submitted a written request for a 4-week deferral to the September 28th, 2016 Planning Commission meeting.
I'd entertain a motion for request for deferral.
Move deferral, Lust.
Second, Core.
Jerry, please call the vote.
Core,
Yes.
Harris,
Yes.
Lust,
Yes.
Sunderman,
Yes.
Weber,
Yes.
Shear,
Yes.
Hove.
Yes.
Motion carried 7-0.
Is there anyone here today wishing to testify on special permit number 16009 rather than waiting until September 28th? It doesn't appear to be, so move on.
Okay, public hearing, under public hearing, item 4.1 is county special permit number 16003, Conestoga Lake Estates for 15 single-family lots and property generally located at Southwest 91st Street and West Pioneers Boulevard. This is final action by the Planning Commission unless appealed to the county clerk within 14 days. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed on this application?
I see none. Tom?
Tom Chaka, planning staff. This request is for Conestoga Lake Estates First Edition preliminary plat. It's on West Pioneers and Southwest 91st, just north of Conestoga Lake. This is the area of the preliminary plat. The lake is down here on the south side of West Pioneers. This preliminary plat originally was approved in 2005 for 14 lots. This amendment is basically just to add one lot. This lot right here, as it exists today, the application is to subdivide that lot into 2 lots. Each lot would be right at 4 acres. This is zoned to AGR. The minimum lot size in AGR is 3 acres. This is a preliminary plat, which basically means if they meet all the conditions of the subdivision ordinance, they're deemed to be approved. This application does meet all requirements of the subdivision ordinance and the zoning code for AGR zoning. Each lot will have its own private water, well, and sanitary sewer system. Really, that's all it is.
Questions for Tom?
Tom, we were provided a copy of the minutes from the county board hearing back in 2005 when there were initially 15 lots proposed, and they reduced it down to 14 lots. Is the lot that we're now asking to be subdivided the same lot that the county board expanded into one larger lot at the time?
No. This is the preliminary plat originally submitted in 2005. The condition that the county board put on said redraw lots 4, 5, and 6 to reduce the total lots from 15 to 14. I'm not sure why that condition was put on. Reading the minutes from then is not clear as to why they put that condition on. And it's kind of planning in the county attorney's opinion. We're not really sure if they should have put that condition on because of it being a preliminary plat. You know, preliminary plat's a bit different than a special permit for a community unit plan where with a special permit, they're asking for concessions usually, and the planning commission or city council or county board has some discretion in the approval process. On preliminary plats, there really isn't the discretion. In the county subdivision ordinance, and this is under county, it's outside the city 3 miles, so it's under county review. In the subdivision ordinance, it says, under preliminary plats, if upon hearing the commission shall find such proposed plat to satisfy the requirements of this resolution, it shall approve said plat. That's section 3.08.
So basically though, this lot is not the one that they made into larger lots.
Correct.
Other questions for Tom? Maya?
Was planning's original recommendation to approve as was with 15 lots?
15 lots, yes.
And then, could you explain why this is final action with us, when the county board took action last time?
The rules have changed since 2005. Now all preliminary plats are final action at planning commission unless they're appealed.
Okay, thank you.
Lynn?
Building in the 100-year floodplain, is that possible?
The floodplain's not there anymore.
It's not there.
It's been removed.
What caused that?
I don't know. I just know now that it's no longer in the floodplain.
Because of any construction or just because they redrew where the
No, I mean,
floodplains
you
were?
just look at the FEMA floodplain maps and it's not in a floodplain any longer. Asked Ben Higgins to be here even though it's outside his jurisdiction, but he might be able to shed some light on that.
Ben?
Hi, my name is Ben Higgins. I'm with Public Works. What happened was the state decided to remap a lot of the Zone A maps, and so Zone A is just doesn't have elevations on it. And so they remapped all the Zone A maps in Lancaster County, and when they remapped it, they just remapped that one out of there. They've remapped a lot of floodplains out that were formerly in. It was just some new standards with FEMA that went through there. I don't know all the details behind it, but I do know they remapped all the Zone A floodplains in Lancaster County, and that was one of them, so.
Any other questions?
Could I have the lawyer? Is there anybody from legal?
Yeah. Dave?
Could you just educate us a little bit on the difference between discretion in one area and not really having discretion in this area?
Sure, absolutely. Dave Durbin, Deputy County Attorney, Lancaster County Attorney's Office. In other instances, we've had some exciting issues where we had a lot of discretion to put conditions on. Those are for special permits. And in those special permits, there's actually provisions in the resolution. It's a planning commission or the county board has the discretion to put on a variety of different conditions to protect the public safety and the health and welfare. In this case, the language is pretty clear in the resolution that the commission shall approve if the proposed plat satisfies the conditions. So by having the language shall, it's a directive and it's an absolute requirement that it be approved if all the boxes can be checked.
Okay, and our planning commission notes said that normally this would have just been approved administratively, but due to the condition placed on it by the county board, reducing the number of lots, it had to be heard by us. So explain what requires it to be heard by us today.
I don't know that it was required, but we saw that this was something that was a little unusual. We're really not sure of the provenance of that condition and really of the propriety of that condition in the first place. And we thought that it was better that we had a public hearing to resolve this whole issue, as opposed to just trying to get it through the normal administrative process.
Other questions? That's it, thank you. Is the applicant here?
Hello, everybody. My name is Michael Fosterman. I'm the owner of the lot in question. I've got a
Michael,
couple-
could you give us your address, please?
Yeah, I live at 2025 A Street, Lincoln, Nebraska. Any other?
No, go ahead. Sorry.
I'm gonna talk quickly about some points of the opposition in regards to my lot splitting. First off, thanks for hearing our remarks and having us today. Safety was brought up. Nebraska statute 54-401 states that livestock owners are liable for damages done by stray or trespassing animals. The laws are similar to any liability I have for my own animals. You know, I have to maintain my dogs on a leash, etc., and I'm responsible for those damages. I grew up in an ag community. I've been around animals, both domestic pets and ag operations animals, my whole life, and I know and respect the value of safety and actions around those animals. So, that being said, I'd like to go on to my PowerPoint. As Tom said, here's the preliminary plat showing my Lot 1, Block 3 right here. Here's an aerial view of the entire Conestoga Lake Estates. This right here is my section. Here's my lot line, if you can see that grass mowing line. And here is the northwest corner area of my lot looking down. As you'll see, there's a fence there that does provide a barrier between my property and the neighbor's ag operations. The next point is the addition of one lot will change the rural settings. Rural, as defined in the United States, is 999 people per square mile or less. My wife and I, my late wife, we had planned on living on the far property line right where I'm standing in this photo. Aside from the two adjoining houses, the neighbors to the north and the neighbors to the east of me, the second house that I wish to build would be more than 250 feet away from the next closest neighbor and more than 700 feet from the next closest after that. Adding a house for my mom and sister to help with my 2-year-old son does very little to affect the rural setting, especially compared to the, I'm sorry, I skipped a couple slides, pardon me, especially compared to the zoning and changes to the area. You know, in this area, half mile to the east, there's around 100 houses that can be put in there. Over to the west, there's around 20 or so that I've concluded that can be built, which, so one more does very little to the rural feel of the area. Next on their list is watershed. As Tom said, originally mine was in the floodplain. This is the original floodplain map. This is the floodplain map as of 2013, the day we went and signed the papers for our land. As you can see, none is in the floodplain. Initially, my first action as an owner, I took the small rut and I dug a slightly larger rut and made an embankment with the soil to allow the water that comes onto my property from everybody to the north of me to flow through my property and exit to Conestoga Lake. At the lower end of my property, I did place rocks and boulders to act as a dam to slow the flow of water and stop the transmission of any sediment off of my lot. At the due to the trench and the lower excavation in this photo, this little body of water in the photo, that is directly after the 5-foot culvert. When I dug this trench and this lower excavation, it actually lowered the discharge point because prior to that, there was 21 inches of sediment inside that culvert. Okay, when I dug it, it allowed all that sediment to wash out of that culvert, which actually improved the watershed for my neighbors to the north, the Sidlow residents. At the annual HOA meeting in June, I attempted to present my initial plans. Technical difficulties prevented me from finishing. However, I explained my wishes to handle the water and sediment that sheds off my neighborhood to the north through my lot. I also vowed to do everything in my power not to affect how water sheds off anybody else's property onto mine. And I also additionally offer to use my equipment while it's on the job site to help anybody with their watershed issues. I have applied for official permission with the Army Corps of Engineers. They're the only regulatory body that has anything to do with my plans. Actually, my meeting is finally tomorrow morning at 9 a.m. with the Army Corps, Richard Chong, to finalize the delineation of wetlands or the lack thereof on my property. But realistically, all these properties in this picture have ponds. It's very similar to what I'm talking about doing on mine. The NRD has provided me with the elevation of the spillway for the lake, which is 1,252 feet, and this map of the National Wetlands Inventory. It shows the Pioneers Road right down here at the bottom of my rut at 1,245 feet, meaning any water that sheds onto my land will easily flow either through the culvert under Pioneers or over Pioneers before it ever poses any danger to either my lots or the houses on the lot. The NRD and the Natural Resource Conservation Service has stated verbally they have no jurisdiction or concerns with these plans. And this is the plans, the meandering river to handle the water is what's shown in this photo. You'll see at the top here is that 5-foot culvert that comes through here. This is what I wanted to do as my primary residence. The other residence would be for my mother, and this one is the west property. The next point I wish to talk about is the large amounts of fill for 2 buildable sites and the strain on the road that the opposition has brought up. I have a degree in construction management from the University of Nebraska, and I feel blessed to have all the knowledge associated with that achievement. I've been putting together plans that will need no fill to be brought in or put any strain on the roads. I'm aware of my rights to build according to the Lincoln Municipal Codes in regards to any elevation I wish to, since it's not in the floodplain. And my mother's and my house will both be built without changing how the water comes onto or leaves my property. The accusations that I'm not willing to properly control my erosion is false. As I said, I put a rock pile at the end of my trench and this other assembly of boulders to prevent erosion. In our HOA covenants, Article 5, Section 19 states that each owner is responsible for erosion control and for the damage due to the lack thereof. In this photo, a neighbor to the north has obviously no erosion control. This road over here, another area with no erosion control, and luckily I have videos of all the processes since I bought the land. Regardless, none of that is relevant here, but I just wanted to point it out for the record. The next point was more demands on the water table. As you see in the 2005 minutes, domestic water wells of approximately 10 gallons per minute usually do not impact the wells of neighboring properties. That's according to Scott Summerside with UNL. Speaking with a lot of different engineers about this, they say the 15 gallons per minute load that a house is rated for now has absolutely no significance on the area. The next section is damage to the effectiveness of the covenants and decreased value and desirability of our lots. Article 5 of our covenants, Section 2, states that the subdivision of the lots is not allowed. It is an unfair section as it applies to only one owner, that is myself. And as you heard from Tom, we meet all the requirements for the planning committee in regards to subdividing my lot. Article 8, Section 2, the severability of our HOA covenants. If the invalidation, it says, in the invalidation of any one of these covenants or restrictions by judgment or court order shall in no way affect any other provisions which shall remain in full force and effect. Okay? Meaning that any judgment that you guys have today will not affect our covenants, and I have no problems with our covenants. And actually, I appreciate the value of our HOA. So, moving on to the next section, from.
Could you wrap up, please? Proceed.
Yep.
Thank you.
Again, I'm in compliance with the requirements for the AGR and the municipal codes as far as setbacks. There are no environmental, economic, or aesthetic impacts by allowing me to build a second house for my mom. The city of Lincoln has done the process of dredging as shown in these photos, and on a smaller scale, this is exactly what I intended to do, improve my lot, handle the watershed, and provide safety for our home.
Thank you.
And that is it. Thank you.
Any questions? Thank you.
Thank you.
Is there anyone here wishing to speak in support of this item? Please come on up.
Hello. My name is Barb Faustman. My address is 1919 Folkways Boulevard in Lincoln. And I again thank you too for the opportunity to speak in favor of the property split. I am Michael's mom, and I would like to explain the reasoning behind the request for this split. Michael has presented all of the legal documentations or all of the necessary things that we needed to go through to do this, but here is the reasoning behind the split. Michael and Jenny bought the property on July 12, 1913, which was Michael's birthday. He and Jenny were so excited to be getting married, to start their family, and to build a home to raise that family in a nice, secure neighborhood, a place where they could actually know their neighbors and the kids could play together without concern for security. After losing Jenny, our worlds were shattered, both ours and Jenny's families. If you've ever lost a spouse or a partner or a best friend, you know the roller coaster of emotions that we were going through and continue to go through. I lost my husband in 2011, so I knew what was ahead for Michael. At that time, I was living in Bellevue. I became an instant caregiver for Michael and for Robbie. One of my daughters asked me how long I was going to be in Lincoln, and without hesitation, my answer was 4 or 5 years. It soon became evident to all of my family that I needed to sell my home and to move to Lincoln. After staying 24/7 for 4 months with Michael in his home, I purchased a home on Folkways Boulevard. My daughter, who was living in Scottsbluff at the time, also changed her job and moved to Lincoln so that we could be available to help Michael. I continued daily to be at Michael's home, helping him to put Robbie down for the night, and then I could go home. In October, when Michael went back to work, he began building a house for his brother-in-law, Jim, Jenny's brother. On Black Friday, he had an accident which nearly severed his left hand, which we now call lefty. After his extensive surgery and the abundantly clear to all of us that he was going to again need 24/7 help and caregiving. The recovery involved physical therapy 3 or 4 times a week, and he couldn't drive, wound care, and Robbie care. As he healed, he became more independent in his and Robbie's care, and I was again able to go home. The second surgery was 9 months later in August, which began the process all over again. In February, he had a puncture wound on his index finger, which immediately became infected with strep, resulting in hospitalization and surgery. Now he was limited to using lefty, and his right hand was bandaged from his elbow to his fingertips. The second surgery was 3 weeks later, followed by several months of wound care and doctor appointments. Besides caring for Robbie and for Michael, I help in the office with the bookwork that Jenny used to do. As we struggle to find a new normal, if there is such a thing, Robbie is our constant as he keeps us going. He is our pure joy and a blessing from Jenny. but it is also the renewed heartache of what she is missing and what Robbie is missing out on. We were reminded of the 3-year to build from the association, that it was fast approaching. We appreciated the patience and the understanding of the association because of all of our difficulties. As we began to discuss the plan for our house, it became extremely difficult to discuss the same plan that Mike and Jenny had. I don't actually know how the split of the property came up, but it appeared to be the solution for our family to move forward. It would be able to give us 2 homes, one for my daughter and I, and one for Mike and Robbie, so that we could be in the close proximity that we needed to be. They would have their private space, and we would have our private space. We were looking forward to living in this nice, secure neighborhood that Jenny and Mike had dreamed about, and that is why I was in favor of the split of this property.
Thank you. Is there anyone else here wishing to testify in support of this item? Is there anyone here wishing to testify in opposition to this item? Please come forward. One at a time. Yeah.
Hello. My name is Peter Reincourt, and my wife and I own the farm property to the west. And I stood before this
Sir, could I
planning
get your
commission.
address?
Sorry?
Please? Could I get your address, please?
9700 West Pioneers.
Thank you.
I stood before the same board in 2005, so I can clarify the comment about why we went from 15 to 14. Very simple reason, which was also addressed by Mr. Faustman, and that is safety. Fence line in particular, and at that time I had a 2,200-pound bull held back by 5 barbed wire strands. Anyone who knows farming and Angus beef would know that that is an illusion. The bull just sort of plays with your thinking that it's going to hold back. At the time that this decision from 15 went to 14, I believe it was based mostly on my comment that that would not be a safe proposition, because if you look at the original plat, you have lots 4, 5, 6, 6 being the one closest to our fence line. That was changed from 5, 6 to 1 unit called 5, which allows the property owner to build the house a fair distance away from the property line, my property line, and on the other side of the waterway. There's a waterway that runs from the north to the south, as you've seen in the pictures. It allowed, and at that time, this is 2005, at that time, the floodplain designation was still in force. And we have been on that property. This is actually my wife's family home. They've been there since the 30s. In 1967-68, we had a 5-inch rain. I was in a boat directly up to Pioneers Boulevard, and I could have just lifted the boat up and would have been on the Faustman property because there was water standing there at that time. My firm belief is that had the lake not been drained in 2014 and 2015, when we had the rain last May, we would have had water standing in that lot that we're talking about. Now, having it as one lot is acceptable for the simple reason that if you look at the properties the way that they have been built, we have 13 houses up. All of those houses are on the ridge. meaning that they're several hundred feet away from the waterway on the west, which faces us, as well as the waterway on the east, which faces the Stewarts. All of the properties, all of the houses are that distance away. Now, to me, that is the key point in terms of safety. Because the proposal by Mr. Faustman at this moment puts that house within, I believe, the 50-foot limit to our property line. As far as I'm concerned, that's way too close. Now, the other thing that happened during the 2005 decision was that the former owner, Mr. Paul Green, was to have constructed a suitable fence on the property that he was selling, meaning the west line of his property, the north line of his property, the east line of this property. And as I read in the notes, it says he was to come up with the cost of that fence to the satisfaction of the agricultural businesses around him. Okay? That brings me to another very serious point in my opposition here. That fence was never built. We got stiffed. That fence building was essentially rolled over to the new homeowners, which they were not aware of. And you have a proposal now to approve this. And I am very seriously concerned, going from that experience I had before with Mr. Green, that unless I can be assured that we will have a substantial fence between the two properties, that I am going to be liable, clearly, for lawsuits. Because I don't believe what we have, which is the requirement, the 5-strand barbed wire fence, is really sufficient. I want a substantial fence that will keep cattle out. Now, at the time of the 2005 hearing, I made the comment that I would prefer to have a chain link fence, because I thought that would be sufficient. I'm not worried so much about the cattle. I'm worried about people coming from the other side. And you heard about a small child, you heard about dogs. We have had dogs on that property that have gone through that barbed wire fence that I have up now. And I am just very much afraid and very much concerned that if that happens, that I will be, again, liable legally for damages. Now, in 2005, I simply said, and this is Mr. Larry Hudkins who was on the board, I would like to have, I can put an electric fence up, move it back 1 or 2 feet from my property so that a child reaching through can't touch it. And he said, you better not do that, because I would still be liable even though it is on my property, clearly on my property. That would keep my bull out, but it wouldn't keep keep a child or a dog out.
Could you wrap up, please?
Yes, sir. So I'm just looking, you saw also the ditch that he dug. I have a real problem because I'm not sure if there was permission needed for that, because it certainly pushed a lot of sediment onto the other side, the south side of Pioneers Park. And the Army Corps of Engineers, or whoever they've hired, they've been digging, they dug for more than a week to get all of that stuff out of there this year. So I'm very much opposed to having 2 houses on there if one of those houses is really close to our property line. Okay, thank you.
Thank you.
Questions?
Any questions? Thank you. Is there anyone else here wishing to testify in opposition to this item? Please come forward.
My name is Chad Stevens. I live at 9045 West Burnham in Denton, Nebraska. Just to emphasize on what Pete said there, I don't know, switch to that. But just to confirm what he was saying, there was a newspaper article in the Journal Star in 14 November 2005, and it just
You'll have to
A little bit,
lift
we
it up a
can't see
little
the
bit.
highlight.
basically it just said that they were just concerned with the article just talks about the safety concerns about that, and then the strain on the agricultural environment, and so then that's what was approved. And then also just to emphasize what Pete was saying, the original plan was because of the floodplain that only a house would be built here on the lot being discussed today, nowhere near Pete's land. And so the real concern was the one house that was proposed to be that close to the fence line, which then that's why the decision was to be 2 lots. So one house would be here, and then there would be just the one house there outside the floodplain. And an additional concern, which I know Mr. Fossman hasn't had his meeting with the Corps of Engineers, but my house is at the other end of the exact opposite end of the development right here. And it's lower than all the rest of the houses except for the houses that Mike is proposing to build. And then also just to the north here is Jerry Sidlow's house, which was on the redesigned lot. What Jerry and myself learned during our building is the Corps of Engineers came in and said, you have to build it to at least an elevation of 1,265 feet, period. And so it'll be interesting that Mike will learn this, and what that means is, and that's why I said it in the letter to you, is that he would have to put in a significant amount of fill, because the Corps of Engineers is going to tell him that his house has to be higher than the land is right now. So, and then our concern, if you look at this, the terrain feature, if he has to put in all that to raise that up to 10 to 15 feet, number one, I don't know if I'll have enough room then to slope it off and still stay within his property lines. But then also he's going to be blocking the water flow that we've seen several pictures of in that wetland, where will the water go? So, at a minimum, I think the Corps of Engineers need to weigh down, because that's what they told my builder, and who was also the builder of Jerry Sidlow's house, is we had to build up our houses. They couldn't be built at the elevation that was presently on the land. Okay. Then also, I serve as the president of the Homeowners Association, and as you saw from the majority of the neighbors, they're very sympathetic and to Mike's situation. We want him in the neighborhood, but we really want our covenants to stand, no subdivision, so that there won't be infringement upon or negate our covenants in the future. So without any questions.
Any questions for Mr. Stevens? Guess not. Thank you. Is there anyone else here wishing to testify in opposition to this item? Please come forward.
My name is Brad Poole, live on 9155 West Burnham Street. I'm on the side of lot that Mr. Postman have. I get a couple things to tell. Anyway, whatever decision is, earlier decision is to build a fence. What Greens fell on us, even not saying about building fence and anything. Now we have to build that, homeowner association. Next things, in the case, Mr. Faustman split that lot in 2 and sell both because he's construction guy. But in that case, the other guy would bought that lot, is responsible to build a fence or do something. And I have third question for you. In a case, if you split that, can everybody of us on the same agenda split our lots on 2 or 3 or 4 or 5? If that can happen every 5 years, something change. If one side is decision made, why are we changing that now? Adding one lot. Can we change in 5 years my lot on 4, the other lot on 3 or 5 because city is coming there? Or are we gonna stay this way? That's all. Thank you.
Thank you. Is there anyone else here wishing to testify in opposition to this item? Please come forward.
My name is Jerry Sidlow. I'm the landowner just straight across from the...
Can you give us your address, please, Mr. Sidlow, and just speak into the microphone right over there?
9210 West Burnham, which is Denton, Nebraska, 68339. I'm right across the street from the lot that he's wanting to separate. When I bought in out there, I was under the impression that there would only be one house built there. And now he wants to split it up for 2. The plans that he has submitted seem to keep changing all the time. There's a culvert that runs through there that I believe is 48 inches tall. His first plan was to divert that down to a system of 2-foot culverts, which won't work in any fashion because that 2-foot will plug a lot easier. And they needed the 5-foot or the 4-foot there to get the necessary drainage. So by putting that down to a 2, he's going to create a flood zone behind it. And so that's one of the reasons I'm opposed to it. Secondly, I knew one house would be across the street from me, which was no big deal, but by putting 2 up there, he's basically blocking off my entire view to the lake area over there. We do have quite a bit of wildlife out in that area that runs through all of our lots out there. And I guess I like to go out and sit out there and view the wildlife, not have to look out at 2 houses out there now. We do have other areas available, of course, but if we start splitting that one up, why not split up a few more? The plat was put out there at 14. Originally it asked for 15. And to appease the farmers in the area and to get it passed through, they dropped it back to 14. Nothing has changed in that time frame, and I cannot see why it would be beneficial to anybody to put another lot out there. When he was asked at the meeting if him and his mother were planning on living there permanently, neither one of them could commit to what was going on. Therefore, I don't feel that the purpose of this is for any other purpose other than to build and sell. And I'm hoping that it's not going to turn into a rental place out there, because rental properties are never taken care of as well as a property that's owned by an individual. And that's the main reason I am against this. And I know that most of them in the association has voiced their opinions against it also. Thank you.
Thank you. Any questions? Thank you. Is there anyone else here wishing to testify in opposition to this item? Please come forward.
I'm Jane Reincourt at 9700 West Pioneers, so also Peter's wife, and also I'm the member of the Bredenberg LLC, which owns the farmland. My brother and I own that. And I outlined this in a letter I wrote to you, but I wanted to also bring up that one of the very positive things in not splitting the 2 lots is that along with all the other neighbors who border our fence, We have agreed that it's very good to have the area of the waterway and the area along between our fence and the waterway to be kept as a natural area. When Jerry Sidlow just mentioned watching wildlife, I think that's something that all of us appreciate. It's a place where a lot of wildlife goes through. And also having this buffer along the whole fence line alleviates the danger of people being too close to the fence and the cattle and getting into trouble that way. We can envision this being really nice if we have a natural area there that's in prairie and native plants, and a lot of the neighbors want to cooperate to do that, which we think is excellent. If Mr. Faustman just is able to build his one house and have the waterway there in a way that's environmentally sound and adds to that, that's wonderful, but we can't imagine the house being that close to the fence, and then this other plan, which we think is very good, working. So I believe that's all I have to say. Thank you.
Thank you. Is there anyone else here wishing to testify in opposition? Please come forward. I'd remind everybody just to bring up items that have not already been brought up and don't repeat what others have already said.
Name is Wayne Burcham. I live at 3677 Southwest 91st, just up the stream from Faustman's lot. And we were under the impression that when we bought out there, each house out there is worth a lot of money. And it's not to brag about that, that's just a fact of life. There's a lot of people that put their life savings in it, and they don't want to have decreased value in the houses or anything like that. Otherwise, I mean, we could see, I would think we'd be able to see a reduction in taxes that we pay. So my point is, we bought under certain conditions that everybody signed off on. We knew where we sat. We're up on top of the hill. Michael Faustman's down to the bottom. He knew he was buying down there. He knew the water runs through there. Therefore, you would think that he would want to build a house that would keep him out of the floodplain more than in it. He had a nice drainage ditch down there that was not causing any problems at all. It was draining water good. He come in and reconstructed that, and it caused sediment. So I guess my point is, I don't see where there's a plus to making two houses. Let's get it back to kind of what it was before, and let's get a one house on it. Like everybody said, we'd love to have him there as a neighbor, that's fine. But let's kind of go with what the original plan was. Let's not get crazy about the thing. That's all.
Thank you. Is there anyone else here wishing to testify in opposition to this item? Okay. Tom, you want to come up? We might have some questions for you. Anyone have questions? Maya?
Can we talk about the required setback as far as the house and the fence that keeps the cattle in?
The setbacks are just what the AGR zoning requires, which is a 15-foot side yard setback. The preliminary plat, the existing preliminary plat had no other conditions. Even though the guy on the north did end up building his house, further to the east, there was nothing preventing him from building his house over here. The floodplain went up like this. This was the floodplain area. He could have built a house in here. He could have built a house back here.
Under the current conditions, because they could build one house, they could build it literally anywhere on that lot as long as it's 15 feet.
As long as they meet the setbacks of the district, yes.
And as long as, I guess, the Corps of Engineers would have to approve it.
The only other condition about locating of the house is that it has to be north of this line right here. Whenever you have subdivisions, residential within 1,320 feet of a publicly owned lake, there's a special permit required, which was done. Part of that special permit is that a house cannot be located closer than 600 feet to the boundary of that lake. So from the south side of Pioneers Boulevard to this line is 600 feet. And basically the reason for that is safety from people if they're in the state recreational area, if they're firing any type of weapons. So he would have to build it up in this area.
And Tom, nothing that we do today affects the enforceability of the homeowners association covenants, does it?
Correct. That's a private matter.
This may be a legal question, but we've heard that there is some uncertainty if the conditions should have been put in the first place by the county board going from 15 to 14. Is there a question of the added condition of the fence and whether that should have been put in there, or is that standard practice?
No, that would probably fall in the same questionable category. It's just another condition. When I was talking to Tom earlier, we noticed that there was a special permit that was there's a public hearing on a special permit at the same time, and as we discussed earlier, in special permits, there's some discretion about approval, whereas in preliminary plats, there's really not. So perhaps the direction wasn't really clear where those conditions were to be put, but they wound up in the preliminary plat resolution.
And does that follow with the property? So is Mr. Faustman in fact obliged to?
Well, the special permit is not for granting X number of lots or reviewing grading or drainage plans. The special permit is specifically states to allow dwellings within a certain distance of a lake. So the special permit is just granting and saying, okay, the state, Game and Parks is okay with this housing development within 1320 feet.
So does the fence have to be built or not? Or is it unclear?
It's unclear. It's in the resolution. I don't know that the county would be the one to necessarily enforce that, but it's in the resolution at this point.
The fence goes around the west, the north, and the east of the whole development, right?
I believe that's what the condition talked about, the west, north, and east side.
So can you make one landowner build the fence himself and then the rest of it the homeowner association take care of, or does the homeowner association got to take care of the whole thing?
I don't know. I guess my question would be, when that condition was put on, that was to the developer of this development, and the condition was put on that developer. I don't know if it can be passed on to individual property owners.
Right. The way, once this got passed on to an HOA, there's probably an agreement that would direct, where those obligations and duties would lie, and that's not something we're really interested in here, but normally when you have a developer who takes on obligations and passes off to an HOA, those would devolve upon the HOA, but I can't say without looking into it, and it's really not what's at issue here.
Chris? Yes, sir.
Can you talk a little bit in more detail about liability between the properties and ag uses, working ag uses, and the residential?
A lot of what we heard was concern about trespass. There's going to be a lower level of duty to any trespasser. So say someone trespasses on someone's land, you have less duty to warn them of dangers than you would to someone who's been invited onto land, for instance. So, but there still are some duties without getting into the whole theory of negligence and property.
But is it for animals, is it your duty to prevent your animals from trespassing on other property, or is it?
It's not gonna be the other person's duty to protect themselves from animals, which was kind of how it was framed. It would be, it's your animal, it's your property. So
Okay.
I think you would have that responsibility
Okay,
as the animal owner.
okay. Lynn, you had a question?
Yeah, is there a minimum lot size in this AGR area?
It's 3 acres is the
Okay.
minimum lot size.
And just a quick glance through here, there's no other lots that are greater than 6 acres, so.
There's no other lots in this development that are at least 6 acres that they could subdivide. The next biggest, largest one is this one, 5.5 acres. So even if he subdivides, each one is right about his, one's 4.5 and one's 4.19 acres.
I have another question. So, in that regard, it looks to me, and I don't know that we have a record that says this, but it looks to me that maybe the main reason that, I think it was Lot 1 in the original plat, preliminary plat,
Yes.
the only reason that remained at 8 acres was because of the floodplain.
Most likely.
Most likely. I
Most
mean, I
likely.
guess we're speculating.
Because
but-
most of that lot was within the floodplain.
Right, so when the floodplain went away, or if the floodplain wasn't there in 2005, it's likely that the preliminary plat might have shown 2 lots then, in that location.
Could have been,
Going back to Janelle's comment about, is it the same lot as that time, which it's not.
right.
Okay.
Yes, sir.
Well, there's been some questions about culverts and such, and I presume that'd be in relationship to the roads that are already there. The county engineer would still have to sign off on any of that type of work, wouldn't he?
Only what, if anything, affects the road. I've talked to the county engineer, I've talked to the NRD, I've talked to Public Works. It's outside the 3 miles, so Public Works has no jurisdiction. County engineer has told me, since it's on private property, they would not review a grading plan for it. They would only say something if it affected the road somehow. NRD has said it's not their jurisdiction. Basically, the only jurisdictional entity that I could find is the Army Corps of Engineers might have some authority over it because of its, I think mainly because of its location to the lake. The email I got from Paul Zillig at Lower Platte South NRD is saying, we have no authority over this drainage. We can review it and make comments, but they don't have authority.
Can I ask?
Sure.
This might be a Ben question, so I can ask Ben from here. Is that drainage channel likely to be waters of the U.S., do you think?
I can kind
Or
of
can you,
answer
do you know
that,
that?
yeah.
I didn't mean to.
I got an email.
I didn't mean to
from NRD on
bypass
that,
you, but
too.
I thought maybe Ben would know.
The NRD said, very likely is. Said the owner would need to look into a 404 permit because he will be working in a channel for the waters of the state.
Okay. Sorry,
other
I didn't
questions?
mean to bypass you.
That's true.
Any other questions? Thank you. Applicant rebuttal?
Thank you again. I'll make it really quick. As you've heard, all the conditions are met to allow me to do this. I'm working with the Army Corps of Engineers on that permit already. It was filed a couple of months ago. The value, there's no way I can diminish the value of my neighbors unless I would build something like a $200,000 home out there, which that's not my plan. I know all the values of the homes are in the $500,000 to $600,000 range and up. That's where I plan to build in that range. The fence and the liability, there's going to be liability whether I'm 500 feet away or 200 feet away. There's no way that anybody can say that people won't go in the natural waterway or the side of the property where people don't want anybody. So as long as the setbacks are okay and I've met all conditions, I compel you to send this through as a pass approval. Thank you.
Tracy?
I do have a question for you. So you mentioned, you plan on building, valuable homes there. Are both going to be, these big homes, or is, one going to be smaller than the other?
I call them castles.
Okay.
In my own words. They're both large, in the 5,000 to 6,000 square foot range, which is pretty much double what the minimum required by the covenants are.
Okay.
So, and I've spoken with my realtor, asked him many questions. Is there anything I could do that would negatively affect the value of my neighbors? And he said the only thing would be if you built a trailer park or a junkyard or that type of thing out there. So.
You said you have a plan to meet with the Army Corps of Engineers.
Tomorrow morning, 9 a.m.
Have you discussed this 1,265-foot level?
No, actually,
visited
that's
with
not
them?
come up at all. And I'm wondering if that was something that was because in 2013, when the FEMA revised the floodplain, maybe that was a rule prior, because I know that Stevens and them built prior, 2006 or so time period, 2008. I'm not sure, but it's prior to the floodplain being revised. So I'll find that out tomorrow. But regardless, one thing I can tell you about my waters of the United States, which I agree that the water that flows out of my property does flow into Conestoga Lake, which defines that. My land does not have hydrology, which is one of the requirements for a wetlands, which is one of the things that says whether I can do or not do any of the work around my property. And furthermore, that trench that it does exist, Richard has told me that the Army Corps of Engineers only has jurisdiction over that trench plus 2 feet on each side of the trench. So regardless, I have the ability to move soil from all other parts of my property to build up if I so needed to. So as far as what I can do with my soil, that is allowed.
Any other questions? Guess not. Thank you.
Thank you very much.
While we were talking about the fence, planning found that although there was originally a motion to amend the preliminary plat to add the fence condition, a week later, when the resolution was actually voted on, that was withdrawn and removed. And so the final version of the resolution does not have the fence condition. It does still have the 15 to 14 condition, but does not have the fence condition. So it's really not an issue at all. Just want to make sure that you were aware.
Thank you.
Thank you.
You have any other comment or anything else you'd like to say? Okay. I'll entertain a motion.
Move approval, last.
Second, Sunderman.
Discussion?
Yeah, I'll go first.
Thanks, Janelle.
I think, the decision before us is, does it meet the requirements for subdivision? And it does. So I think to that extent we're pretty constrained on what we can do here, and the application should be approved. I would urge everybody to, though, look into the homeowners association covenants and the effect that might have on your plans. But given that, I do think I have to support the motion to approve the subdivision.
Thank you. Others? Lynn?
I drove out there yesterday and drove around. Very nice homes, nice little neighborhood that you have there. And I really don't see how 1 or 2 more homes is going to change anything. It's already kind of got a rural, urban feel to it as it is, and this isn't going to change that. And as far as the property line goes, I know when I was a kid, whether my house was 1,000 feet away from a fence or 200 feet away from the fence, it's not going to make any difference. I'm comfortable with putting a house in that area. He's mentioned he's from an ag background. He'd be used to animals, and he'll watch out.
Anyone else? Maya?
I'd just like to say that I am sympathetic to the homeowners who were relying on an action by the county board and made plans according to that action. But I do think that 10 years is an appropriate time to revisit a preliminary plat, and especially when conditions seem to have changed and we're no longer in the floodplain. So as long as the applicant meets all the conditions for where to build and according to all the ordinances, I don't see a problem with approving this.
Ken?
Maya just said what I was gonna say.
One more thing, if I may. I'm really disappointed with the county board's notes on this thing. They made a fairly big decision, and here 10 years later, we can't figure out why they did what they did. I'm just disappointed in that.
Anyone else? I'm going to support the motion. I appreciate the folks that have talked. The fact is that the house could be built anywhere on that lot within 15 feet. If he builds it in, may not be a floodplain, but if it gets flooded, that's his liability. He's got to figure that out himself. So at any rate, I think, and as far as the fence, that's something that hopefully you folks can work out and figure out yourselves. Please call the motion.
Okay, this is a motion to approve the county preliminary plat 16003. Core?
Yes.
Harris?
Yes.
Lust?
Yes.
Sunderman?
Yes.
Weber?
Yes.
Scheer?
Yes.
Hove?
Yes.
Motion carried 7-0.
At this time, anyone wishing to speak on an item not on the agenda may do so. We're adjourned.